Be seated. We're still on the record. All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the use of the word nonsense is what you're talking about originally.
Originally, Your Honor, but then in rebuttal there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth, right? I mean, and again, so multiple objections. This is essentially governed by State versus McDaniel. And the final argument to the jury of prosecutor is governed by a unique set of rules which differ significantly from those governing counsel in civil suits, and even those governing defense counsel in the very same criminal trial. These special rules follow directly from the prosecutor's inherently unique role in the criminal justice system, which mandates that the prosecutor not act as a zealous advocate for criminal punishment, but as the representative of the people in an effort to seek justice. For example, that when a prosecutor argues that a defense is meritless, she cannot belittle the defense either in the abstract or suggesting that the defense was raised because it was the only defense that would succeed. So there's lots of law in this, Your Honor, and essentially these comments, the repeated comments, constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some bench conferences that that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating a jury, demanding that if there's not a guilty verdict that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city, Brooklyn Center, as I recall.
Although I think that is the alternate we just dismissed.
I do not believe so. I
thought it was, but go ahead.
Now I'd have to go back and double check my notes. So, yeah, I mean, I just think that the sum total of this trial happening in such a public context, number one. Number two, while all of this, I mean, the media attention is profound. I have admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has found its way into even fictional television. Your Honor, there were I was advised of 2 television shows in the course of the past few days that specifically involved references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone, or you shut off your TV, you shut off your computer, and no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, I mean, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning.
Understood.
To make that clear. And so I had moved, based on this, again, for a mistrial. The idea is that it is a public trial. I think the court has accomplished that, but the media attention is so profound. It is such a, it is such a modern comparison. I mean, it's such a modern problem to have, where literally I walked from this courtroom into the courtroom where I've been permitted to stay. During the course of this trial, I've received literally thousands and thousands and thousands of emails. So much so that I don't even look at that particular email anymore. So, but my phone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that I just don't know how this jury, it can really be said to be that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
Your Honor, the state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, well into jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes of the exact statement or some kind of a declaration. And I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Nelson is referring to in terms of any of this. And so I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court has provided instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they would be capable of doing that. And so without any sort of specific offer of proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied.
And Your Honor, I make my comments, in the context of this is all such an evolving situation. Obviously, I spend my weekend preparing for closing remarks. And I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement them.
Yeah, you can supplement the record with whatever media reports. I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational. But you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions, and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of a few days ago that a juror may have been talking to a major media outlet. We checked with that major, and it appeared right from the beginning that it was third-hand hearsay telephone game. That media outlet, in fact, took it very seriously, did a nationwide contact of all of its reporters and staff to check out any veracity, and there apparently is none whatsoever. Nobody from this major media outlet made any contact, and I find that credible, and so just for the record, I pass that along. Now, I think we still have the memorialization, but we also have to talk about a Blakely waiver.
Yes, Your Honor. So a couple of things. In terms of the memorialization of the sidebars and the objections, we had previously provided, and we had suggested that we provided our memorandum of the objections that the defense had made at sidebars. I am going to propose, rather than just simply reading through and taking an hour's time, that we submit those objections in writing now that
Right.
happened, and in consultation with the state, and they can include their objections that we did not include.
It'd be nice to include just essentially a stipulated pleading that sets out what the objection was and what the court's ruling. There's no need to repeat what the arguments were. The only thing that you need to preserve for appeal is what the objection was and what the court's ruling was. So I would encourage both parties to get together and figure that out and file it reasonably quickly. I mean, it doesn't have to be today, tomorrow, or even the next day, but just to get on it while our memories are fresh.
And if there's a discrepancy between the memories, Your Honor, I'm expecting that we're going to be able to come up with a stipulated document, but if there's anything that needs to be set out, we can just indicate our contrary memories of that, and it should be pretty simple.
Absolutely. I think that would be the best way to memorialize this in any case. All right. Other than Blakely, do we have any other issues to make a record of?
No, Your Honor. I think we just need to have some administrative discussions about questions, timing.
And we can do that in a chambers discussion. All right. With regard to Blakely.
Sure. I have not yet had Mr. Chauvin execute the written waiver. Again, I do have it. We can print it and get that taken care of. But I can do an oral waiver now if the court
If you would.
So, Mr. Chauvin, you can take your mask off. Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called a Blakely notice, or a notice to seek an aggravated sentence, correct?
Yes.
I have explained to you the bases on which the state is seeking to have an aggravated sentence imposed in the event of a conviction on any one of the counts here, correct?
Correct.
We've discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have a right to have a jury decide if you violated, right?
Correct.
And I've advised you that the state has to prove those grounds beyond a reasonable doubt.
Correct.
And we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I've advised you about that, right?
Yes, you have.
Now, do you want a jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge Cahill to make those decisions?
I'm willing to waive it and have Judge Cahill decide on those issues.
Mr. Chauvin, again, I'm going to address you individually because this is another one of the decisions you have to make for yourself. This is a waiver of your jury trial right when it comes to aggravating factors. Normally, we would submit a verdict form with interrogatories with a question and yes or no options, and that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof does not change. It's only that I'm going to be the one who's answering those yes and no questions. It was always true that based on whatever the answers are to those, that I would be the one deciding if they constitute legally substantial and compelling circumstances, and we would expect briefs from both sides on that. Do you understand that?
Yes, I do.
So basically, I will be answering those verdict form questions instead of the jury, applying the standard of proof beyond a reasonable doubt. Is that what you want to have happen?
Yes, sir.
All right. I would ask that you file a written Blakely waiver in addition.
We will, Your Honor.
All right.
I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right. It's an administrative memorialization, so you can do that off the record. All right. Counsel, I'm going to talk with basically give instructions to the alternates. Give me 20 minutes, and then why don't you come on back. All right. Otherwise, we are in recess until we hear from the jury.
All right, so once again, listening in here to the trial of Derek Chauvin, now the case in the hands